पटेल
ABPS पटेल
इलेक्ट्रॉनिक एग्जाम सुनते वकील से नीचे चौपान आगे
हाँ सर दलीलों માટે છે
कंपनी
एग्जाम से जब नहीं
जी
हाँ सर बेटा कौन
साहब
सेशन केस 22/19 खुशबूबेन
खुशबूबेन
अनीताबेन कीर्तिबेन चांदीबेन निसर्गभाई
નિસર્ગભાઈ
શું નામ તમારું ખુશબુબેન પછી ચાંદની અને કીર્તિબેન 2 4 5 6 वकील से एम राजपूत
વકીલ છે રાજપૂત
वकील से जीपी गोयल वकील से जीपी गोयल
વકીલ છે જીપી ગોયલ
बचाव पक्ष में साक्षी नंबर 1 लास्ट टाइम आया था डॉक्यूमेंट लिंक मीडिया गया था आगे डॉक्यूमेंट दिखाऊं बजट सेशन के 100/20 आरोपी पीछे दूसरी मात्रा दीक्षित वकील से एन दीक्षित
વકીલ છે દીક્ષિત
एबीपीएस पटेल
ABPS પટેલ
सेशन के 52/21 किरण बावरी
કિરણ બાવરી
2 नंबर की एग्जाम सुई है वकील से आरएन मकवाणा
વકીલ છે મકોડા
एक नंबर हूँ
एक नंबर बात
एक्सेप्ट
हम्म
शायद आगे से
शायद छे में
जी सर
साहब अरे मकवान
जी सर वकील से आरएन मकवाणा
વકીલ છે મકોડા
सेशन के 174/22 रविराज सिंह कुशवाहा
રવિરાજ સિંહ
भगवान सिंह चौहान
ભગવાન સિંહ ચૌહાણ
3 नंबर हाजिर हर्षवर्धन
एक ने बे
1 नंबर बाकी रविराज सिंह कुशवाहा
રવિરાજ સિંહ પુષ્પા
भगवान सिंह चौहान
ભગવાન સિંહ ચૌહાણ
वकील से एक गढ़वी
વકીલ છે એટલે ગઢવી
वकील से जेवी शेख
વકીલ છે જેવી છે
सेशन के 84/23 गोवर्धन भाई
कौन सा
आईओ एसटी देसाई
આઈએસ દેસાઈ
बीजू को
વિજુભાઈ
बजी છે ને
जी सर भजन सेशन के 121/23 साहिल ठाकुर प्रताप भाई आकाश
આકાશભાઈ
जयवी ठाकुर साहिल राणा गीताबेन पटेल
ગીતાબેન પટેલ
वकील से जीएस सोलंकी
વકીલ છે જીએસ સોલંકી
नीलेश अशोक भाई वर्मा
कौन
નિલેશ અશોકભાઈ વર્મા
प्रकाश भाई परमार
પ્રકાશભાઈ પરમાર
ये पैसों सेशन के 138/23 तबरेज भाई लतीफ मियां 2 नंबर बाकी सब अल्ताफ पठान
एक छे
एक ने त्रण
यस
वकील से एमएल से
વકીલ છે એમએલસી
वकील से एस पठान
વકીલ છે પઠાણ
सेशन के 743/23 अशोक भाई पटनी
અશોકભાઈ પટેલ
छना भाई कालीदास वकील से एपी तोमर
વકીલ છે એપી તોમર
सर एक पंचायत आ जाए
रोके कौन से में
बीपी तो
वकील से एपी तोमर
वकील साहेब विक्रमवाल
अशोकभाई पटनी,
अशोकभाई पटेल
हैदर अली शेख,
हैदर अली शेख
नरोत्तमभाई दातड़िया,
नरोत्तमभाई दातड़िया
डॉक्टर लक्ष्मणભાઈ કોકાજી.
सेशन केस 999-23, सेंट्रल जज मोहम्मद आरिफ, साथी बाकी वकील LADCTA व्यास,
एलसीडीए व्यास
साहेब कौन है? आयु आजाद
जी।
એલડી સે ટીવી.
यस सर.
सेशन केस 265/24, हसन पठान, मोहम्मद सलीम, मोहम्मद
मोहम्मद
सलीम,
सलीम
वकील से NF कांची,
वकील साहेब गाची
अभी
ना सर ये
એ બાજુ.
रेडी। स्पेशल PPMG कापड़िया,
स्पेशल पीएनजी कापड़िया
वकील से HA पटेल,
वकील साहेब पटेल
वकील से LR पठान,
वकील साहेब पठान
बता पीडीसी में
ये व्यास आया है.
એલડી સે
I have already explained it.
Yes, you said that earlier you were at
That
different
earlier
place
there was another point
and
of-
those persons
where I'm saying
conveyed that you should leave this, therefore you have left that.
Understand, and no sooner that coming on between 12 o'clock, I have taken that.
Yes,
That is what I have explained this.
yes,
And the another is that the use code word which is.
No, like
used
your-
for-
yes, that your
so that-
contention
That is also not proved.
that
I
as per
said
the,
that none of the circumstances are proved beyond reason.
yes, the prosecution
therefore-
case was to the fact that code word was Ramjan and he was to respond as code word
What
was
was that
Muhammad.
issue to call Muhammad?
Muhammad and he was to
respond that term.
as Ramjan. But here the call given as such was Muhammad Ramzan, Muhammad Ramzan, Muhammad Ramzan,
Aren't they make call Muhammad Ramzan.
to which he
That too
replied.
has not responded. But
Yes.
as to after lapse of much time, when his Ramzan is coming, he responded.
Yes,
And એમાં પેલા admit કર્યું છે કે he responded because to
Yeah.
Ramzan.
yes, he
Not
said
to-
that I am Ramzan Ghani.
No, he responded the word Ramzan, not the Muhammad.
Yes,
મોહમ્મદ કીધું હોય ને એમ કીધું હોય પહેલા મોહમ્મદ કીધું હોય ને એને રમજાન તરીકે રિસ્પોન્ડ નથી કર્યું.
yes,
But he responded the word Ramzan only.
yes.
So these are two judgments on which I am relying.
જામીન રજૂ કરી નાખે. Yes.
The one is of Justice Roshami Raju and Mr. Patel. It is 2002 criminal appeal number 148.
Yes. Yes,
Ashish Bhatt, respondent of the state of Madhya Pradesh.
yes.
Now, if this is a landmark judgment, so far the circumstantial evidence is concerned.
Yes.
May I take my loss to the note D of his on the next page? Note D.
One. Ashish Batham.
Okay.
Yes, note D.
We are also of the view the doubtful and suspected nature of the evidence sought to be relied upon to substantiate the circumstances in the case themselves suffer from the serious infirmities and lack of a legal credibility to the merit acceptance in the hands of the court of law. Since the very circumstances sought to be relied upon themselves stood seriously undermined the existence of a proof or one of the most stray circumstances stray circumstances.
Yes,
Why I'm saying a stray,
yes,
सब એને કપડા એના કઢાયેલા ન હતા, નેટ કોરી હતી.
yes,
These are all stray
yes,
in the chain of break and dislocate the link in a such a manner so as to irreversibly snap the link in the chain of circumstances regarding in a different and appropriate as well as impossible to consider even one of the more of them along the other either sufficiently constituting or provide the necessary basis to legitimately presume the guilt of the appellant.
yes,
This is what and the paragraph important are. I am saying that this is not judgment on a similar fact.
yes, yes.
I am not saying that.
You are considered
It is a
Circumstantial evidence. less
No,
three
that-
circumstance.
There are six.
There are six. Yes,
The principle which should guide weight with the courts administering the criminal justice in dealing with the case based on circumstantial evidence has to be
succinctly laid down.
successfully laid down the early as 1952. Candidly reiterating the times and again, but yet has come necessary to avoid to the same once against in the case having regards to the term of even the manner considering the undertaken in the case by the court below in women to Govind versus so and so and so and so mother Maharashtra. तब जरा वाचવામાં મને જરા ચશ્માની
Yes, sir.
મારે એક આંખે દેખાતું નથી, એક પર તકલીફ છે.
Yes,
એટલે
yes.
કદાચ કોઈ વાંચવામાં ભૂલ થાય
ના, ના.
તો I may be pardoned.
Yes.
In dealing with the circumstantial evidence, the rules specifically applied to such evidence must bear in mind. In such cases, there is always a danger that conjecture and suspicion may take the place of a legal proof. This is what the conjectures and the suspicions may take the place of a legal proof. Therefore, it is right to recall the warning addressing to the groans and alterations to the jury in a register versus Hogde. That also case has been very. It said that mine was apt to take the pleasure in adapting circumstances to one another and even in training them in little, if need be so, force them to form the part of one of the connected whole, and the more igneous the mind of the individual, the more likely was it, considering such matter, to overall the misleading itself to supply some legal need that wanting to take for granted some fact consistent with the previous theory and necessary to render them compliant.
Yes,
It is well to remember that a case where the evidence of the criminal nature, circumstances from which the conclusions of the guilt is to be drawn should be first instances be fully established, and all the facts established should be consistent only with the hypothesis of the guilt of the accused. Against the circumstances should be of a conclusive nature and the tendency, and they should be such to be exclude every hypothesis,
but the one
but
proposed to be.
one proposed to be proved. In other words, there must be a chain of evidence. So to complete is not to leave any reasonable ground. This is the argument.
Yes,
Not to leave the reasonable ground for the conclusion consistent with the innovation of the evidence. That is the base of it.
yes,
What has to be kept in mind. Now, para 8 my lord में सीधी तेरा है.
yes,
Realities of truth part. The fundamental and basic presumptions in the administration of the criminal law of the justice delivery system in the innocence of the alleged accused and till the charge are proved beyond reasonable doubt. So on the basis of clear, this is important, on the
Yes.
basis of clear, cogent, credible or unimpeachable evidence, the question of indicating the punishment or punishment on a accused does not arise merely carried away by heinous nature of the crime.
yes,
Merely it is heinous nature of the crime is not,
yes,
but the evidence should be cogent, credible, and impeachable evidence must be there to
Yeah.
prove every circumstance. I am not reading all of them,
Yes.
but then
para 9.
para 9 on the 9 parallel. So far as the case in the hand is concerned, it becomes necessary even the threshold to find out whether the court below, this is important, whether the
Yes.
court below endeavor we find out that each and every incriminating circumstance has been clearly established
By
the
reliable and
reliable-
evidence.
clinching evidence.
Yes,
This is what the
Yes.
requirement, the court has to.
yes,
Otherwise, the facts which is, I mean, the not relevant to my case, the
Yes.
facts on which the observation has been made. Then because these circumstances they have dealt in this case, but these are the only important aspect which has to be required into mind while deciding the case of a where the accused is to be implicated by using the circumstantial evidence.
yes.
The second one judgment case of
Kantilal.
Supreme Court.
Kantilal versus State of Gujarat.
There, my lord, the important, I just want to draw my lord's attention to para 6, 7, 8.
Yes,
It is on the basis of the ego circumstances the appellant was found guilty of having murdered the deceased and person. We have heard the learned counsels for the parties and we have given our anxious considerations to the fact of the case. If actually the circumstances narrated hearing above had been established beyond any reasonable doubt, there could be no difficulty in concurring with the findings of the court below. However, we find that the sum of the link in the chain of circumstances has not been established by the prosecution either in accordance with the law or the beyond reasonable doubt, because of which, in our opinion, the serious doubt arises as to the correctness of the prosecution case, which will be discussed by us here in Kinnock.
Yes.
In regards to the circumstances that the appellant was taken to the deceased and had financially transactions, we have no doubt that the prosecution has established the fact. Therefore, we proceed on the basis that these circumstances stand proof. So also, the second circumstance is noted above that the accused was in need of the money and he had given 2 checks which obviously were not encased by the deceased. Therefore, to the extent the appellant had a motive and would be and could be accepted. The third circumstance is noted here in our opinion, has not been established by the prosecution. Thus, if based on the evidence of period 21, the neighbor so and so, there is no doubt that this witness resides very close to the house of the deceased, and is also possible that on 8 so and so date at so and so time, the night might have been present in the house. But we have serious doubt whether this witness has actually seen the appellant in the house of the deceased. It is an admitted fact that at that point of time, there was no light in the house of the deceased. Now, certainly, similarly, as I said in my case also, they said that it was the clothes were not clean, the net was clean, the desk was also clear, and there was no fish. Now, the admittedly fact that none of the officers has gone on the vessel to verify this. That is admitted.
Yes.
And some of them have said that we do not.
Yes.
Now so far, because what can be the evidence? The oral evidence adduced by one witness only, that is PW number 2, who has also not occasion to go upstairs. No occasion to go upstairs. Now that statement had been so far the quantity of the fish is concerned. The quantity of the fish is concerned. They said there was nil. There was no fish at all. The other witness, one of the witnesses said there must be 4 or 5 fishes. Now the very authority, while conducted the Panchanama at the port, from the very vessel, they recover more than 80 to 90 kilo of fish. So that statement appears to be
False.
not reliable, cogent,
Yes.
and so far that vessel, place of vessel I have just argued out. And I have said that so far the connectivity they wanted to establish through the code word used, that is also not established by them, and therefore there is absolutely no evidence against the present accused that it is he who was. You cannot put a finger on it. That it is he who was come to receive the contraband item. And another minor aspect which is required consideration is that as it is apparently clear that on IFB there are 11 to 12 cruise members are there. 11 to 12 cruise members.
Other was allowed to go, except one.
Except one, they did not choose. If I had been intentions by that. And that one of the witness, their statement had been recorded by the investigation officers. And he has disclosed, one of them, I have examined as a defense, has disclosed in what circumstances they have changed the place. And an investigation officer has also admitted in his cross-examination, yes, this statement was made. This statement was made by the defense witness in the statement before the investigating officer. That was the question, my lord. Whenever any such evidence had been induced
Yes.
by the, I mean, either of the witness which been examined during the investigation,
Yes.
it was the duty of the investigation officers to investigate on that aspect, whether actually it is true or not. Let us say that way. But no investigation had been made. And his statement has not been challenged by the prosecution.
Yes.
So it appears that I can make a definite statement of it,
Yes.
that he's been falsely implicated as a recipient of the
Yes.
consignment, having no role in this.
Yes. Yes, તમારે કઈ કહેવાનું છે?
હું પર ઇવન ધીરેનભાઈના આત્મહત્યા થઈ જાય તો બંને થોડું રિફ્લેક્ટ થશે.
No, Mr. Patel has argued out the matter.
સર, આપણે
એમને
જજમેન્ટ
ક્યાં?
આપવાની વાત કરી.
Judgment આપવાના છે કઈ?
મારી પાસે તમારા જજમેન્ટ લઈને ગયા એ કે હું રજૂ કરી.
એટલે
મને અને એટલા માટે ના આપી દીધી.
Yes.
મને એવું કહે નહીં કે હમણાં જ આપવાના હતા તો મારે વીકનેસ છે એટલા માટે હું કરી આપી દીધી.
Yeah.
But sir, judgment બી 42% 52 ઉપર એ ઉપર છે
હા.
અને 57 ઉપર છે.